Call this meeting to order. Welcome to meeting number 51 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to Standing Order 108, Sub 2, and the motion adopted on January 30th, 2023, the committee is beginning its study on Canada's bail system. Today's meeting is taking place in hybrid format pursuant to the House Order of June 23rd, 2022. Members are attending in person and the room and remotely using the Zoom application. I won't go into details on that because I think everybody knows the rules on that, and it's and all the members are in the House today. I just want to let Monsieur Fortin know that the sound has been checked for everyone, so we're good to go with interpretation.
Thank you so much, sir.
You're welcome. And to begin this study on Canada's bail system, we have with us officials from the Department of Justice, Matthew Taylor, General Counsel and Director, Criminal Law Policy, and Chelsea Moore, Counsel, Criminal Law Policy. I want to welcome them here. I also want to thank them and all the others and the analysts and clerks and interpreters who worked, was it last night? I'm trying to remember. Yes, last night till late. So on Valentine's Day, I really appreciate all your work, and to the clerk and all the staff back here, so thank you so much. Mr. Garrison, you had a question or point of order?
Thank you, Mr. Chair. I trust that the minister's not here today due to scheduling conflicts and that he has every intention of appearing since we have successions. And I know he's had the benefit of direct discussion with the premiers, so I'm just asking for confirmation that we will eventually see the minister as part of these hearings.
Thank you, Mr. Garrison. My understanding, yes, we do have confirmation he'll be coming, and I think right after the break at one of the meetings then. So I don't have it in front of me, the exact one, but we have confirmation he will be attending. So over to you. I'll give you 10 minutes because it is a deep topic, unless your submissions are only 5, but you have 10 minutes. I
think we're somewhere in between, Mr. Chair. I think we targeted 7, so if I talk fast, it's 5, and if I talk slow, it'll be 10.
Yeah, okay.
Thanks very much for the opportunity to be here today to support you and participate in your study on Canada's bail regime. Les lois canadiennes sur la mise en liberté.
Canada's bail laws are clear, and they set out the framework by which accused persons are to be released or detained prior to a trial for the offences they have been charged with. As provided in subsection 515(1) of the Criminal Code, the starting point is that an accused should be released from custody unless the prosecutor can show why the detention of the accused is necessary. This starting point reflects our common law history and our Charter of Rights and Freedoms, specifically the presumption of innocence and the right not to be denied reasonable bail without just cause.
Si le point de départ est la mise.
So while the starting point is release, release is not automatically guaranteed and is not permitted if there is just cause for detention. The reasons why somebody can be denied are found in subsection 515(10), and there are 3. 1, to ensure attendance in court or prevent flight risk, to protect public safety, including any substantial likelihood that the accused will reoffend, and to maintain confidence in the administration of justice.
Each ground constitutes an independent basis upon which bail can be denied, and a decision on whether to detain under these grounds will be informed by the evidence available to the court, including the criminal record of the accused. For example, that the accused used a firearm or other weapon, or that they have a history of violent offending may militate against their release on public safety grounds. These same factors may also support a decision to detain someone on public confidence grounds, but public safety is not the only frame by which the public confidence ground applies. Other factors that matter in this context include the strength of the case against the accused, the seriousness of the alleged offense, and the circumstances surrounding its commission. This ground, public confidence ground, is about balancing all relevant factors and recognizes that public confidence in the bail system is essential to its proper functioning and to the proper functioning of the justice system as a whole. The grounds for detention anchor the bail system, and they do not change depending on who must show whether detention is warranted. They are not altered by the fact that a court must also take into consideration other factors, including the principle of restraint, which is found in section 493.1, or that the accused is Indigenous or from a vulnerable population that is overrepresented in the criminal justice system. In other words, a court is still required to detain someone if there is just cause to do so, and there are no appropriate means of addressing risk if the accused is released. And those appropriate means could include impositions of conditions as part of a bail plan, reasonable and relevant conditions. Canada's bail laws provide clear guidance on who is responsible for demonstrating when detention is warranted. The default, as is the case for most aspects of criminal law, is that the state bears the responsibility to show why detention is warranted. However, there are a number of cases where it falls to the accused to show why they should not be detained. These reverse onuses reflect Parliament's intention to make it more difficult for an accused to obtain release in certain situations that align with the grounds of detention, the grounds that I talked about earlier, and as such, these reverse onuses may operate like a shortcut. Examples of reverse onuses include cases where an accused is charged with organized crime or terrorism offenses, certain offenses committed with firearms, or cases of intimate partner violence where the accused has been previously convicted for the same. In the end, however, these reverse onuses don't guarantee detention. Detention must still be justified on the three grounds. I think you're all aware, and I think I've heard you speak to this already, that the Prime Minister has committed to working closely with the provinces and territories to ensure that our bail system, meaning our bail laws in the criminal code, and their implementation by the provinces and territories is working effectively. This commitment followed a January letter that was sent to him by all premiers, advocating for a new reverse onus, amongst other things. You may wish to note that FPT collaboration on bail is long-standing. Significant collaboration led to the development of the bail reforms in former Bill C-75. And since last fall, so preceding the letter from the premiers, we have been working closely with the provinces and territories on bail issues, including how the bail system responds to repeat violent offending. This work continues. Minister Lametti has recently called for a special meeting of Justice and Public Safety Ministers on bail, and we expect that that will occur in the next few weeks. The meeting will provide an opportunity for all jurisdictions to identify concrete ways to address current challenges to ensure that any solutions proposed do not negatively affect the achievement of other important objectives and to affirm core principles. That concludes our remarks. We appreciate your attention, and we look forward to answering any questions you have.
Thank you. That was great timing, only 6 minutes. So we'll go to our first round of questions, beginning by Mr. Caputo for 6 minutes.
Thank you, Chair, and thank you both for being here. And I apologize if I get into some nitty-gritty. I apologize, but these are important questions. Now, if you look at sections, say, 515, particularly 515 sub 6 and 524 of the code, I take it you'd agree that generally anybody who is under release for one set of charges and is alleged to commit another charge, particularly a hybrid offense, is in a reverse onus. Is that correct?
Hi. Yes, that's correct.
Yes.
Under 515.6, there's a reverse onus if the allegation involves a breach of certain conditions of bail or a summons or any other court order.
Exactly. So getting into a reverse onus is not a rare thing. You'd agree with that, correct?
I'm not sure. I think I'd have to look at the data before I would say if it's rare or not.
It's certainly not rare that somebody has a breach of bail before the courts. We can acknowledge that.
Again, I can't confirm if it's rare. It does happen that someone comes before the court with a breach of bail.
I can't give evidence, but I could say it's a pretty regular occurrence that somebody is in a breach of bail situation. Okay, so you're familiar, I take it, with cases like, I'm going to talk about 3 cases that have really changed the bail landscape: Antic, Zora, and St. Cloud. Are you familiar with all three of those cases?
Yeah.
Okay. So, and I want to get at a bit of a tension here that we're looking at. Because under a reverse onus, if you read the reverse onus provision, it really should be such that a person who breaches generally should be detained, absent the accused showing cause why they shouldn't be detained. In other words, the accused must show a justification for release. Is that correct? And if you look at the wording of, say, 515 sub 6 or provisions under 524, or I think it's 512.3, all of those provisions, it appears that Parliament's intention was to create a burden, and a high burden at that, for release in the reverse onus. Do you agree with that? That's a yes. I'll just say yes. You nod your head.
Yes, they signal Parliament's intent to make it more difficult to obtain bail for those offences that are
Certainly.
listed.
So if people are regularly satisfying the reverse onus, either people are getting good at satisfying the reverse onus, or Parliament's intent isn't being followed. We can agree there?
I'm not following.
Okay.
In a specific case?
No, but just generally, I mean, the whole point of reverse onus is to make it difficult or more difficult for a person to achieve bail. And perhaps I'll take a step back. The reverse onus, or the application of reverse onus, is meant that people have a much higher burden to climb in order to achieve bail. Is that correct?
So the burden is on the accused as
Right.
opposed to being on the Crown?
Yes. And the point being that they have to show cause themselves, not the Crown themselves. Okay. I don't know that I'm going to, I probably before we get too deep into that line of thinking, I'm just going to go to something just a bit more perhaps germane. We have section C75, we have Antic, we have Zora, and we have St. Cloud. Now, St. Cloud is a tertiary ground case, but it's a bail case. And my reading of St. Cloud, now it's been a couple of years, my reading of St. Cloud says that bail detention on the tertiary ground should not be rare. In other words, it is okay for detention on the tertiary ground to be frequent. You took that away from the case too?
Yes, it shouldn't be limited to exceptional circumstances.
Exactly. And it shouldn't be limited to the worst case either. And for those following along, the tertiary ground is it would shock a Canadian. It would shock a Canadian if this person were released. Did I summarize that fairly, just in very basic terms?
I think you're right. I think the court talks about the public's confidence. A well-informed citizen understands the principles and objectives of the bail regime. But I think shocking the conscience is probably a good shortcut for describing the kinds of situations.
Perfect. Yep. Nowhere in St. Cloud does it say detention should be exceptionally rare on that tertiary ground. Do you agree with that?
I think.
It says the opposite, really.
Earlier point is it's its own ground. It's not reserved for exceptional cases.
Okay. So then we have Bill C75 and we have Antic and Zora. And I'm not going to get into the nitty-gritty here, but the gist of Antic and Zora actually is to say detention should be very rare. That's how I read those cases. Do you agree with that?
So I read those cases as saying that it's sort of the cardinal rule that the Supreme Court talks about. The detention ought to be release ought to be the norm, and detention ought to be the exception.
Okay.
So there's a presumption in most cases that an accused ought to be released.
Okay. So do you see there being a conflict there between, say, St. Cloud and those other two cases I mentioned, where it's, detention shouldn't be rare in the one case, but in the other cases they're saying bail should be the rule, not the exception. Do you see how there's a tension there?
I'm not sure if I can start. I'm not sure there's a conflict per se, and as our opening remarks tried to convey, the grounds for detention are the grounds for detention, and so I think with the latter principle and the principle of restraint and these other important concepts to the bail regime, the idea is that all of these they're signposts essentially to the court. You have to take into consideration. What is the least restrictive measure on liberty to assure attendance in court, to protect public safety, to maintain confidence in the administration of justice. So so that there is a principle of restraint, or that there is, the requirement that consideration be given to the specifics of Indigenous or marginalized accused, doesn't mean that detention is off the table. It's about the process upon which a decision is taken, rather than favoring one outcome over the other.
And perhaps,
Thank you, Mr. Ubudo.
thank you.
We'll next go to Mr. Nakvi for 6 minutes.
I'm gonna start where you left, so we're all good. The only place I differ from you, you jumped into reverse owner's right from the get-go. But I think we need to have the basic principle discussion first before we get into the exceptions to the principles. So thank you both for being here. So let's start from the top. And you alluded that in your introductory comments. Let's start with the common law. What does the common law tells us when it comes to bail?
So we have a number of Supreme Court of Canada decisions that have been released over the past decade, talking about what we just talked about, which is the cardinal rule that release ought to be the norm and detention ought to be the exception. And that principle really derives from the structure of the code as it stands right now, as well as the charter. But if you look at the structure of the code, the principle of restraint is actually embedded within subsection 515 sub 1 of the criminal code. It's the starting point, and it basically says that the justice shall release the accused unless the prosecutor shows why the accused ought to be detained. So that's the starting point. And then under sub 2, we have the latter principle, which the common law has discussed at length recently in the Antic decision, as well as the Zora decision.
I'm just going to ask you to stop there because I
Yes.
want to come to the latter principle.
Okay.
Can you just interweave in this the constitutional, the charter guarantee in terms of bail?
Sure. So under Section 11E of the Charter, there's a right not to be denied bail without reasonable cause, without just cause. And so there's two aspects of this. There's the just cause aspect of it. Bail can only be denied in narrow circumstances that are tailored to the specific purposes of bail, the proper functioning of the bail system. So public safety, reoffending, those are considered purposes that have been accepted and linked to the proper functioning of the bail regime. Second, the second one was reasonable. So bail must also be reasonable, and that really ties into what we're talking about here with the latter principle and ensuring that an accused is released on reasonable conditions that are necessary and tied to the specific risks that an accused poses if they're released.
Fantastic. Now let's talk about the latter principle because that's a very important part of the common law and it comes out of the charter jurisprudence as well. Imagine, Ms. Moore, that we're in first year criminal law, constitutional law class, and we're fresh young law students, and you're describing latter principle to us.
Right. So the latter principle sets out a presumption for most bail hearings that an accused ought to be released on the least onerous terms and form of release. So we're really looking at subsection 515.2 of the criminal code. And you'll notice from paragraphs A to E, it progressively gets more restrictive. So as you go down each paragraph, the form of release becomes more restrictive. At paragraph 2E of 515, there's a automatic condition of a cash deposit as well as an optional surety, and that's only available to accused who reside more than 200 kilometers away or out of province. It's the most restrictive form of release that we have. So we have paragraph 2.01 of the criminal code that says that the starting point is to release with no conditions, on a release order with no conditions, and then for each more restrictive term that's added to the release order, the prosecutor needs to justify why a more restrictive release is necessary, and they really need to link it back to the specific risks that an accused poses. So, for example, if we're dealing with someone who might be a flight risk, there's conditions that can be imposed, like a cash deposit or deposit a passport. If someone's at risk of reoffending, there's other conditions that can be imposed to ensure that they're following their conditions.
So you went through the criminal code, which articulates the latter principle, which is in compliance with both the charter and the common law. Is that correct?
That's correct.
Okay.
Yeah.
And so now, again, we're going to Basics 101. Who is responsible for implementing those provisions and in particularly the latter principle?
So implementing them. So the judge or justice at the bail hearing is the one that ultimately decides what type of release the accused should be released on. Typically at a bail hearing, the Crown will make submissions on what conditions are reasonable. The defense will also make submissions, and then the judge will decide, and the accused needs to follow their conditions. And what's important to note is that if the accused breaches a condition of bail, they're liable to up to 2 years in prison. So it's a significant...
And administration of justice is the responsibility of?
the provinces and territories.
The provinces. Thank you. Do I still have time or done? 1 more minute. Great. Okay, that's great. So I just want to make sure that we got the foundation. We got the foundation right. And so I know you are a federal crown at Department of Justice, but I'm sure you've got fairly sophisticated understanding of how provinces operate. How do provinces? What methods provinces use to inform their crowns when it comes to the implementation of various things, such as the bail process?
Go ahead.
Well, I think one way that you probably are all quite familiar are directives that are issued by attorneys general in the provinces. So we know, for example, Ontario issued a directive on bail matters in the context of the COVID pandemic. British Columbia has recently issued new guidance to their prosecutors on bail matters involving repeat and violent offenders. And just to piggyback onto the federal perspective, the Federal Public Prosecution Service of Canada, who's responsible for prosecuting in the territories and certain federal criminal offenses in the provinces, also issue guidelines that can be looked at in their desk book, which is on the PPSC's website, that provides information on the relevant considerations in bail matters.
Thank you. Sorry.
I'm done? Okay,
Yes,
thank you.
Thank you,
Well,
Mr. Naqvi. Next, we'll go to Monsieur Fortin for 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. Good day, Ms. Moore, Mr. Taylor. Quite interesting, all of this. Indeed, the application of these rules falls under provincial jurisdiction. Of course, I'm not going to ask you to further address those questions, but on the major outlines or principles that you work on a daily basis, I'd like to hear your view on this. We understand that one of the issues is public safety. One of the grounds, if we release someone, we want to make sure to protect the public. I'd like you to explain this. What are the grounds that will serve to establish that? How do we establish that someone is or is not going to be a risk to the public? Thank you for your question. During a bail hearing, the justice will have a copy, generally, of the person's criminal record. So that's one way of really seeing. If you'll allow me, I'm going to switch to English.
It helps the court to see if there's any past convictions of violence on the accused's record, and to look at whether there's been a pattern of criminal behavior. So that's something that's very important when they're looking at the secondary ground protection of the public. They're also looking at, is this person on bail at the time? Were they on probation at the time of the offense? Often they look at the personal circumstances of the accused. So is this someone who's a stable person? Or is this someone who's likely to resort to crime again if they're released? Does this person have a steady job? Often there'll be a surety that might testify about the personal character of the accused or what they're doing in their life. All of this can be relevant to the secondary ground. When looking at protection of the public, there's a number of other provisions in the code under the bail section, under the bail provisions that also address public safety. I can discuss those if you want.
Quand on va tenir compte.
Correct me if I'm wrong, but I believe we take into consideration the type of charge against the accused. Sorry, I've used the same word multiple times. So let's say there's a firearm involved. That would have an effect. I'd like you to talk to me about that. To what extent will that have an effect? And what distinctions should we draw from amongst all crimes, the crime committed with a firearm.
For the tertiary ground, the court must consider the circumstances surrounding the offense, including whether a firearm was used. And so it really signals to the court that the tertiary ground is relevant to the case when there's a firearm being used. We have a reverse onus at bail, which is quite broad for any offense where the subject matter involves a firearm if the person has already been on a prohibition order. And so, as I said before, this really Parliament has signaled that it ought to be more difficult for someone charged with a firearms offense in that situation to obtain bail. They have the presumption is reversed. So the presumption is that they ought to be detained unless they can prove to the court on a balance of probabilities that they should be released. There are also a number of conditions that a judge has to impose for offenses involving violence or involving a firearm. Conditions that they have to consider imposing. So conditions like, they have to consider imposing, it's a mandatory prohibition on weapons, on the use of weapons, if the offense is alleged to involve a firearm. And they have to, look at imposing conditions that would protect the safety of any victim or witnesses.
Ne trouvez-vous pas que...
Do you not find it strange? I mean, you might have followed the legislative process underway. With Bill C-5 recently, several mandatory minimums have been struck, a number of them. Amongst them, I mean, it was specifically targeting some offenses that involve firearms. I can't remember exactly which ones, but let's say firing with the intent to harm or something along those lines. I was surprised. I had a bit of a challenge with some of these. Do you not find it a bit strange that when we get rid or repeal firearms-related offenses, that in the case of a bail hearing, you might have reverse onus and tell a person, okay, you're going to jail unless you can prove to us that you're not a danger to society, etc. Is that not a paradox, those two principles?
C'est difficile de dire si
It's difficult to say if it's a paradox, but I think it depends. I mean, if you have a mandatory minimum,
context, the reverse onuses that relate to firearms, I think, are very closely tied to the grounds for detention. So that a crime is alleged to have involved the use of a firearm in a robbery or a sexual assault is presumptively seen as something that poses a public safety risk. So it's closely linked to that just cause, the three grounds of detention. And so I think there may be a tendency to want to try and make comparisons between considerations at the bail stage or considerations at the sentencing stage, but they are really, the charter rights are different in those stages. And the purposes of those different processes are different.
Thank you. Thank you, Monsieur Fortin. Sorry. Mr. Garrison, over to you for 6 minutes.
Thank you very much, Mr. Chair. And I'm going to ask the committee and the officials to give me a little latitude here at the beginning, because like Mr. Navke, I think we have to make it clear what it is exactly we're talking about. And I think that the study actually deals with 4 separate problems. And 2 of those have been very high profile in public. And certainly the premiers have been raising those, and that's the problems for public safety caused by repeat violent offenders who achieve bail. And the secondary problem there is public order problems caused by repeat low-level offenders who receive bail. So I think those are 2 things that are very high profile. They are legitimate concerns, and they're part of this study. But we have a bail system that actually is kind of contradictory in that, in fact, we actually detain way too many people before trial. And when you look at the numbers of people in provincial institutions at any one time, most of them haven't been convicted of anything. They're awaiting their trial dates. And what we find, if you actually look at that problem, is those are disproportionately Indigenous people, racialized Canadians, and people with low incomes. And so that's a third problem, I think, that's here. And then a fourth problem what people who do achieve bail, quite often it's more difficult for some people to meet what are thought of as non-onerous conditions of bail, and they end up with a public order or a public administration of justice offense, even though they haven't been convicted of anything. And so I think there's actually those 4 different problems that and I'm going to be calling witnesses on all 4 of those, if I get enough witnesses. And I'm going to be asking you some questions about those. I want to start with the repeat violent offenders. And I think, I'm not going to try and lead you into saying this, I'll just say it. I think there's a consensus that sometimes our system fails to detain people. Maybe we need to tighten that up somehow. And one of the things that came forward in a previous Senate bill was the Section 518 says that prosecutors may present evidence in a bail hearing on previous convictions, on if they're awaiting charges, if they breached conditions before, or failed to appear in court. And the operative word in that section is may. So I'm wondering if we don't have judges sometimes who are making bail decisions because that information hasn't always been put before them. And if we were to change the wording in that sentence from may to shall, we would guarantee that they had that evidence in front of them. So I just want you, that was in a previous Senate bill, and I think it's a reasonable thing for us to look at. And I want to know what you would have to say about that.
I do think it's a good thing to look at. I think our one maybe initial comment on that would be changing a may to a must or a may to a shall in the bail process could have efficiency implications, and I expect you would have expected that as an answer. And I mean, I can't tell you or the committee that that is a reason not to look at it. I think it's something that provincial prosecutors or people who are in the courts would have better experience, a better understanding of whether that's a real impact that would meaningfully result in delays or bail hearings being put over, things of that nature.
But anecdotally, and certainly in the media, we have heard of decisions where the judge appeared not to have the full information on the offender because it wasn't presented at the bail hearing. So apart from efficiency, I'm looking at the other end. The tightening it up might actually have public safety advantages if we were to do that. So obviously, we're always weighing efficiency. And if we're talking about detaining too many people, of course, we're weighing costs against other impacts. When it comes to, again, the low-level offenders, I think that's the second problem. I wonder if we have any statistics, if they're really collected, because I have the feeling they're not, because provinces administer the justice here, about just how many offenders are being released multiple times on similar offenses. I certainly haven't seen anything on that, and I wonder if you have any information about how often that happens.
So we don't have any national statistics with respect to bail at this time. Individual provinces and territories, as I'm sure you know, are responsible for collecting criminal justice system data, including bail data, and sometimes they publish this data on their websites. Statistics Canada provides provinces and territories with the opportunity to report their bail data so that a national data set can be available, but not all jurisdictions are currently contributing to that. But through its integrated criminal court survey, Statistics Canada is able to combine various sources of information to create what they call composite indicators. And basically, this is combined information on the occurrence and outcomes of bail hearings for 7 jurisdictions that report, but sometimes they report differently. So it can be challenging to analyze that data. But justice officials are currently working with Statistics Canada on a special data request to review and analyze the available data.
Certainly something we have heard from the police quite often, certainly locally in my riding, is that this does happen, but it's a very small number of people. And so I wonder if there's any reaction from Justice about us trying to reform the bail system when we're dealing with not the majority of people who go through it, but with a very small number of people going through it.
If you're speaking to the small percent, and I think we've heard that information as well, a small percentage of people committing a significant number of nonviolent offenses, often, as you said, Mr. Garrison, related to perhaps addictions, things of that nature. I mean, I think it is worth the way you've kind of divided up the issues. I think it is important to think about it in all of those terms. I think, is there a public safety concern in those situations? Perhaps not. But maybe there's a confidence concern there that needs to be thought about and looked at in greater detail. To the extent that we have any information on chronic offending, we're happy to provide it to the committee.
Thank you, Mr. Garrison. We'll go to the next round for 5 minutes each. It was Mr. Van Popta.
Good. Thank you, Chair. Thank you, witnesses, for being here. We're here at the Justice Committee studying bail reform and the need for it. And one of the reasons that we're doing this is in response to a letter that the 13 premiers have written recently to the Prime Minister, and I have a copy of that letter here in front of me. So I just want to read a couple of sentences from it and ask for your comments on it. They say, we write to urge that the federal government take immediate action to strengthen Canada's bail system to better protect the public and Canada's heroic first responders. And we all remember with great sadness and shock, really, Constable Greg Pershella being murdered by a person who was out on bail for firearms-related crimes that he was accused of. So this is very urgent for us to be looking into this. Also to ensure that the public remains confident. Otherwise, the administration of justice could be brought into disrepute. But here's the problem that I see. The premiers go on to say the justice system fundamentally needs to keep anyone who poses a threat to public safety off the streets. Well, we all agree with that. But how does a judge determine in advance whether a person is a threat? I'm assuming that, in hindsight, we all know that the person who murdered Pershella was a threat, but did the judge know it ahead of time?
So, as I mentioned, it's a risk assessment that's done at the bail hearing. So there is a provision under 515 sub 3 of the Criminal Code that was added by former Bill C-75 that now requires judges, before making any bail decision, to look at the criminal record of the accused and whether the accused is charged with domestic violence. I think the criminal record is really key to getting at, the history of offending and whether there's a pattern of violence there that is likely to be a risk to the public. Often Crowns introduce occurrence reports if there's been charges laid but no conviction entered, and they can have an officer testify about these reports to say that there's been a pattern of behavior. I'm
going to stop you there. I'm assuming all of that happened in the, I forget what the accused person's name was, doesn't matter, the person who murdered the police officer. I'm assuming all of that procedure was followed, yet he, in retrospect, was a threat to the public.
Any law that has discretion built into it is going to unfortunately result in situations that you just simply cannot predict. We can't legislate to remove any and all risk unless we detain all the time. And the thing is that the Charter says that there must be just cause to detain someone. They can't be automatically detained, but in some cases there can be a presumption of detention, like I talked about the reverse onus situations. Ultimately, if the judge does get it wrong, there is an appeal process that's available under Section 520 of the Criminal Code. So in this particular case, I believe there was a warrant out for his arrest at the time.
So the Premier's letter goes on to suggest a reverse onus on bail must be created for offense of possession of a loaded, prohibited, or restricted firearm in Section 95 of the Code. Now, I know that under Section 515 of the Criminal Code, there are some reverse onus provisions, which I understood have withstood charter challenges. Would adding possession of a loaded, prohibited, or restricted firearm survive a charter challenge, in your opinion?
It's a difficult question to answer. Maybe I can answer it in a slightly different way. That specific proposal is something that we're looking at in collaboration with the provinces and territories, as you would expect. Section 95 is a broad offense, and for those of you who will remember the newer decision, there was another Supreme Court decision, McDonald, that involved an otherwise law-abiding gun owner who stored their prohibited or restricted firearm in a place where, in a second residence. So their license authorized them to store it in their primary residence. They stored it in their second residence. So you have to, in constructing a reverse onus for an offense of that nature, you have to take into consideration the types of situations that would be captured and whether those situations that may or may not pose public safety risks warrant a reverse onus. On the charter question, I think I would say two things. Justice Canada's website includes a dedicated resource on all articles of the charter. It includes detailed information on the bail provisions, including on the reverse onus. I think what a court would want to see in terms of assessing the charter viability of a reverse onus in that space is it linked to the grounds of detention? Is there a just cause associated with it? But as you say, reverse onuses have not been struck in the bail regime by the Supreme Court of Canada.
Do we still have a bit of time?
Nope, I think your time just up. Thank you. Next, we'll go to Mr. Naqvi for 5 minutes.
Thank you, Chair. I think we still got to get through some basics here because we have you, and I just want to make sure that we've got all that. I know people are rightly so getting you in the nitty-gritty, but I just still feel I'm still in first-year law school right now. So I think let's talk about reverse onus. So describe the concept of reverse onus to us in general, and then how it applies to bail in particular.
Sure.
Please and thank you.
So reverse onus departs from the general approach to bail in two respects. First, there's a presumption that the accused ought to be detained, and second, the accused has to prove on a balance of probabilities that they ought to be released, having regard to the statutory grounds. So they have to prove to the judge that they're not a flight risk, that detention is not justified to protect the public, and detention is not justified for confidence in the administration of justice. So those provisions set out at 515 sub 6 of the code signal Parliament's intent that it ought to be more difficult to release an accused in those circumstances. We have reverse onuses, as I said, for accused who are alleged to have breached the bail provisions, bail conditions, sorry. We have a reverse onus for intimate partner violence where someone has already been convicted of intimate partner violence. And we have reverse onuses for more serious offenses like firearms offenses where they're already on a prohibition order. I think that's it for the reverse onus, yeah.
So there are a variety of provisions or types of offenses in the criminal code that fall within a reverse onus requirement for bail.
Yes.
And again, the determination of whether or not that onus is met is up to a justice of peace or a judge who is presiding over that bail hearing.
Yes, so the code says justice, but justice is defined under Section 2 of the code to include a judge of a provincial court. So it could be a justice of the peace or a judge of the provincial court.
Okay. Now, is there I think you touched on it. It was either Mr. Taylor touched on the notion of directives at the provincial level. Am I correct to understand that there is still some latitude or capacity at with the Attorney General at the provincial level to issue a directive that asks their Crown to take a particular position, let's say to always seek refusal of bail, for instance? That latitude still exists?
Yes, since, for example, I spoke to the directive that BC, the updated guidelines that BC provided, they do provide fairly clear instruction on when provincial prosecutors in British Columbia should request that bail be denied based on certain criteria. Repeat violent offending safety risks. It's set out in some detail.
And so can you expand a little bit of what British Columbia just recently did?
I don't know if I can expand. I mean, I know that, and I think Mr. Garrison probably knows quite well. Also, British Columbia has for some time, and I referenced it in my opening remarks, been concerned about the situation of repeat violent offending. So this has been something that we have been working on collaboratively with them in terms of can we make amendments to the bail regime to address this issue. Within their area of responsibility as administrators of justice, they have updated their guidelines to provide guidance to their prosecutors when dealing with accused persons who have been charged with offenses of violence. I think those guidelines, and we can provide those, are publicly available information. I think those guidelines also speak to other circumstances where the specific considerations of Indigenous accused, for example. So we can provide those.
Are you aware of any other province beside British Columbia taking a similar step?
As I said, I know Ontario has issued guidelines on bail. I think they were specific to the COVID context. I have not done, and our unit, I don't believe, has done kind of a comprehensive search of every jurisdiction. But I can point you to, as I said, British Columbia, and at the federal level, the Public Prosecution Services Desk Book, which does provide information on bail hearings.
Okay. Is there reverse onus exists when the accused has been charged with offenses involving firearms, where the accused is subject to a weapons prohibition order?
Yes, there is.
Can you refer to the section?
Yes.
The code?
So it is found under subparagraph 515.6.8. So actually, there's two reverse onuses that link to firearms. So 515 sub 6 subparagraph 7, an offense under 244, 244.2 that is alleged to have been committed with a firearm. And then under subparagraph 8, it's quite broad. It's any offense that's alleged to involve or whose subject matter is alleged to be a firearm if the accused is already under a prohibition order as defined under Section 84. And subsection 5 also deals with reverse onus as well.
Thank you, Mr. Naqvi. We'll next go to 2.5-minute rounds with Monsieur Fortin for 2.5 minutes.
Merci, monsieur.
Thank you, Mr. Chair. Mr. Taylor, Madam Moore, I'd like to get back to this issue of firearms in my 2.5 minutes. I gather that there are specific provisions for these offenses, but not all. And as I was saying earlier, there's the fact that we legislated not that long ago to repeal mandatory minimums for some firearms-related offenses. I'm thinking specifically of discharging a firearm with the intent. There was a mandatory minimum, that it was a 4-year minimum, and then it was repealed. Is that not something that a defense attorney could bring before the judge and say, listen, Your Honor, because we have to look at the seriousness of the offense at that point. Can a lawyer show up in court and say, Your Honor, clearly this offense is much less serious in our society today than it was 10, 20, 50 years ago because the legislator just abolished these mandatory minimums? Is that not an argument that could be brought forward and could be concerning? I think it's always open to a lawyer to try to convince a judge that an offense is more or less serious than another. The repealing of the MMPs was not.
It's not only an acknowledgement that an offense is less serious. The decision to repeal mandatory minimum penalties it was based on the importance of restoring discretion to judges to impose fit sentence in all cases.
Oui, mais on donne.
Yeah, but the judge then has the option not to sentence anyone to jail. And we heard recently in the news in Quebec, someone had weapons at home and then there was no jail term imposed. I think it does indicate seriousness. The legislators doesn't speak to say nothing. Okay, you get rid of the 4-year mandatory minimum, it must mean that it's less serious, no?
I I will say what I've said previously. I think judges and the criminal code provide a structure that the offenses involving firearms are punishable by significant maximum penalties of imprisonment. The Supreme Court, in some of its recent jurisprudence, has reaffirmed the principle that a maximum penalty provides clear guidance. A maximum penalty provided for in law provides clear guidance to the courts on the seriousness of the offense. The example you cite in terms of the decision in Quebec, we're aware of it. There are routes of appeal for these matters, and I understand your point. I think the important piece to remember again is that the law as it operates provides kind of clear signposts. The way the law is implemented, there are situations where the outcomes are perhaps what one would expect. But there are checks and balances within that system in terms of appeal rights, et cetera.
Thank you, Mr. Furta. Mr. Garrison, 2.5 minutes.
Mr. Chair, I'm in the back to basics section again. I think if we keep in our minds that the purpose of the bail system is to protect the presumption of innocence at the same time as we protect public safety, and I think that's kind of the frame we're in. The trick in the legislation and the procedures is to figure out who to detain in that. And I guess I'm back to the lack of statistics. Can you tell me what we know about the number of people are being detained before trial and how long they're being detained?
So what we don't, and Ms. Moore will look something up, but what we don't have is, I think, a breakdown on, for example, the percentage of people who are being detained in custody pre-trial versus the percentage of people who are being detained in custody pre-sentencing. So some of the statistics that we do have speaks to both of those ideas of detention. So we can't parse out which of those are remand, but we do have some limited data sets.
Can you give us some indication of magnitudes here? Because we do see the reports in the media of the large number of people, and the implication is that they're on remand, but I appreciate the distinction you've made. Some are awaiting sentencing. But do we have any magnitude or percentage estimates of how many people are? Because people who are detained before they're convicted do suffer. It has impact on employment. It has both whether you can go to work and what your employer thinks about you. It has impacts on families, and it has impacts on things like drug and alcohol treatment programs.
So maybe I can just give you one data point, and then we can undertake to provide additional data to your question. It's a statistic that we were provided by the Toronto Police, and it's in a report from 2022, and it's specific to firearms offenses. So according to the Toronto Police, in terms of the data they're keeping, the percentage of individuals charged with a firearms offense who were granted bail decreased from 63% in 2019 to 58% in 2021. Percent of individuals charged with a firearms offense who were rearrested for a criminal offense after being granted bail decreased from 44% in 2019 to 19% in 2021. So it's a very limited data.
It's helpful data.
Thank you.
Thank you, Mr. Garrison. Next, we'll go to one more 5-minute round, beginning by Mr. Brock and then ending with Ms. Diab.
Thank you, Chair, and thank you to the witnesses. I didn't think I was going to get around, so this is an honor. You obviously know my background, so I'm not going to mention my background, because whenever I mention my background, I get my colleague, Mr. Yakvi, who was my former boss, chiming in and adding his editorial. So I can inform you, sir, and ma'am, I come at this study with a completely different lens and a different perspective. Unlike my colleague, another prosecutor, Mr. Caputo, I spent a substantial amount of time, 15, 20 years in bail court on a regular basis. And I just want to know whether or not you agree with my assessment. Prior to the release of Antic, I don't know, maybe the two of you weren't even lawyers at that point yet, but I've been around for a long time. Prior to Antic, there was a general consensus that the overall pendulum with respect to serving the needs of the public, protecting the public, and highlighting the protections under the charter for accused was not balanced. That far too many people were being detained for really minor offenses. And there was really a lack of focus by prosecutors around this country to only really argue for detention on those serious cases that posed a risk not only to community safety, but to that of the victim. Antic tried to reinforce that pendulum had shifted too far to the protection of society and the public, and in my view, moved that pendulum a little closer to the rights of the accused. Then we have Bill 75. Then we have another Supreme Court of Canada decision in, help me, Frank, Zora, that reinforced those principles. And now we're left with this perception that the public has that this system that we call the criminal justice system is not in balance. Is that a theme? Is that a focus that you are hearing, that you are reading studies and you're hearing experts talk about this and stakeholders talk about this? Is that a concern at the Department of Justice?
Yeah, I mean, I think it's a very good comment, Mr. Brock. I think let's start with the public concern. When we see the stories that we see in the news in terms of the tragic cases that we're all aware of and that kind of motivated your decision to take this study, the public is going to be concerned, and we understand that, and the minister understands that, and we're supporting the government in looking at solutions. That's why Minister Lametti has called the special meeting with his provincial counterparts. I think the other thing we're hearing, and I think it's perhaps implicit in what you're saying, is that the bail system is fundamentally sound in that it provides clear grounds for detention that are well understood, but that there are concerns that perhaps, as you've said, the pendulum shifts one way or it shifts another way. And so it is about trying to find that balance, and it's not an easy thing to do.
I can stop you right there because I got limited time. I thank you for that. Do you share this belief? And I've talked to many judges, provincial court judges, I've talked to many justices of the peace. We all acknowledge that the vast majority of the JPs, for short, in Canada do not have a legal background. There's no requirement for them to have a legal background. But both those JPs and judges feel that Bill 75 really shackled their discretion. That 75, in addition to the two Supreme Court of Canada decisions in Zora and Antec, has really forced them to consider release, regardless of the circumstances of the predicate offense, regardless of the criminal background, regardless of the number of failed to attends, the number of breaches. That default is the overriding principle. Is that an issue for the department?
Yeah, and I think in our opening remarks we tried to speak to that point directly, which is that the Supreme Court cases that you've talked about, the reforms that were enacted in former C-75, they are principles that inform a process. They don't dictate an outcome. The outcome in terms of detention versus release is very clearly set out. You should be detained. A JP or a judge should deny bail if one of the three grounds have been established.
But there's always a fear of being appealed.
Yes, there's always...
A JP has those concerns, and sometimes, and I'll be very blunt with you, sometimes they err on the side of not being appealed and release and pray and cross their fingers that there are no consequences. But we know that every day across this country there are significant, serious, fatal consequences based on decisions that JPs are making, provincial court judges are making, and in the most recent case, a Superior Court judge on a bail review, correct?
Yeah,
Thank you,
and
Mr.
I think-
Brock. Unfortunately, we're out of time. Ms. Diab for 5 minutes.
Thanks very much, Chair, and thanks for our witnesses. It is an important study. There's a obviously we're studying it. There's a lot of public concern in Canada, but there's also a lot of discrepancies in how different provinces and territories are using this. So it makes absolute sense for us parliamentarians to take a look at this, and I think we were all in favor of this study. I appreciated, because I didn't do criminal law, I appreciated the sort of criminal 101, I did law school, but that was a long time ago. Can I start off with Bill C-75, which is where you ended with Mr. Brock right now? I know it's only been around for a couple of years, but my question to you is, it made certain reforms to the criminal code. Can you tell us, and continue with your response there? How did it bring the law in line with Supreme Court of Canada jurisdiction? And in your opinion and your expertise, what has it done? And is there enough time, since it's only been a couple of years, to kind of assess that?
Thank you for the question. So, as you may be aware or not, the bail provisions of the Criminal Code had not been comprehensively amended since 1972, the Bail Reform Act of 1972. There were a lot of inefficiencies in the bail system with police release and the forms of release, and so Bill C-75 really tried to improve some of those efficiencies in the bail process. One of the provisions that was enacted, as we've talked about, is the principle of restraint under 493.1, which requires judges and courts to give primary consideration to the release at the earliest opportunity on the least onerous grounds. And they also have to, in making any bail decision, consider the circumstances of Indigenous accused, as well as accused from marginalized populations. There had been many calls for reform and many studies done on the inefficiencies in the bail system. The Standing Senate Committee on Legal and Constitutional Affairs did quite a comprehensive study on delays, and they looked at the bail issue in their report, Delaying Justice is Denying Justice, and they specifically recommended that the Minister of Justice prioritize reducing the number of persons on remand across Canada. So the principle of restraint really responded directly to that recommendation. There were also calls for reform from the Steering Committee on Justice Efficiencies and Access to Justice, as well as in several reports that had been conducted. The bail amendments were significantly informed by the Supreme Court of Canada jurisprudence as well. We talked about the decision in Antic, but there had been a history of decisions that were made, but specifically in Antic, which is a unanimous decision of the Supreme Court, which was written by now Chief Justice Wagner of the Supreme Court. He wrote in that decision that there was widespread inconsistency in the law of bail, and stated that the bottom line is that the remand populations in denial of bail have increased dramatically in the Charter era. And you'll see in the Senate report some data with respect to the remand situation. They heard from a witness from Saskatchewan who had said that the remand population went up 97%, over several decades, so that's quite significant. I could refer you to the legislative background around C-75, which is available online if you have questions about that. With respect to implementation of the Bill C-75 reforms, as you know, the reforms came into force in 2019. The bail reforms in particular, I believe, came into force 9 months after that. So it really coincided, the implementation coincided with the beginning of the pandemic. As you know, there were many disruptions to the court system during the pandemic. Many jury trials were adjourned. Officials are continuing to find ways to look at the data to try to measure implementation efforts. There are a number of research projects that are ongoing with officials from Research and the Statistics Division at Justice Canada. If you want more information on those, I can certainly provide them.
So the data is an important point, and I think Mr. Garrison was trying to get that, and I can appreciate you responded by saying that the data there's data available, but it doesn't break down pre-trial and pre-sentencing. I'm not sure why. Perhaps you can tell us why. But the question is, so data is collected on the bail system, or can you tell us what is collected and what is publicly available? I guess.
Very briefly, please.
So I think further to what we committed to with Mr. Garrison, because I know we don't have a lot of time, we'll provide you a list of what we have. We do have limited data from 7 jurisdictions, but as Ms. Moore said earlier, the way that's collected is not consistent across jurisdictions. So we'll provide that to you along with an explanation of the kind of the methodology around it. Thank you.
I want to thank both of you. We have a lot of lawyers in the room, a few former AGs, and so they have a lot of legal questions for you, and I really appreciate your comprehensive and strong answers. So we'll suspend until our next witness comes on, so give it a couple minutes. back. I'd like to invite our next witness, the Commissioner of the Ontario Provincial Police, Thomas Carrique. So we're glad to have the Commissioner here with us. So you have 5 minutes, but you have liberty to be another minute or two since you're the only witness today. And then we'll have a round of questions right after. So over to you, Commissioner Carrique.
Thank you, Mr. Chair and committee members. I really appreciate the opportunity to speak about the concerns I have raised and will continue to raise over the preventable circumstances related to the murder of Ontario Provincial Police Constable Greg Pershala. One of the individuals responsible for the death of Constable Pershala and charged with first-degree murder, Randall McKenzie, is a repeat violent offender convicted of violent weapons-related offenses. Despite showing a concerning pattern of non-compliance with previous weapons and firearms-related prohibitions and other court-imposed conditions, he was released on bail while awaiting trial for additional violent weapons-related charges, including assaulting 3 victims, one of which a peace officer. McKenzie has a violent past with criminal convictions for armed robbery using a firearm, assault with a weapon, possession of a weapon, and assault. He had been subjected to a 5-year weapons prohibition in 2015, a 10-year weapons prohibition in 2016, another 10-year weapons and lifetime firearm prohibition in 2018, and at the time of Constable Pershala's death, bail conditions prohibiting him from possessing a weapon and ammunition. As noted by the Superior Court Justice in his bail review decision releasing McKenzie from custody on June 27, 2022, McKenzie had a record of 5 previous convictions for failing to comply with court orders. Despite all of this, he was released on bail, whereas in the past he did not comply with the conditions ordered, including discarding a GPS ankle monitoring device, which he was ordered to wear while under the supervision of a surety, ultimately leading to the murder of Constable Pershala. Regrettably, incidents of repeat offenders with a violent history being granted judicial interim release and committing further violent criminal acts thereafter is not rare. In fact, in 2021 and 2022, the OPP charged 587 repeat violent offenders for failing to comply with bail conditions. Of these 587 individuals, 464 were involved in serious violent crimes while out on bail, and a shocking 56 of these crimes involved a firearm. In many cases, incarceration is the only effective means by which to protect the public from repeat violent offenders. The public's right to be protected from these offenders must be given far greater weight than is currently the case when bail matters are considered. Consistent with a 2008 resolution from the Canadian Association of Chiefs of Police, currently many police leaders throughout Canada are focused on enhancements to Section 515, subsection 10B of the Criminal Code that would result in conveying the will of law-abiding Canadians and compelling courts to consider factors that must be weighed against the release of an accused. Factors such as preventing the commission of a serious offense, the prior commission of a serious offense while on bail, the prior commission of an offense while using a weapon, in particular, a firearm, the extent to which and number and frequency of previous convictions of the accused for serious offenses, including persistent offending by the accused, and the nature and likelihood of any danger to the life or personal safety of any person or danger to the community that may be presented by the release of a person charged with an offense punishable by imprisonment for a term of 10 years or more. I strongly believe our officers, the very ones who protect our families and communities and Canadians alike, deserve to be safeguarded against the repeat violent offenders who are charged with violent weapons-related offenses while awaiting trial. In closing, I would like to express my appreciation to the Standing Committee of Justice and Human Rights for this study. Together, With a commitment to actioning meaningful and responsible legislative change, we can and must expeditiously ensure appropriate weight is given to public safety concerns when considering the interim release of a repeat violent offender, thereby improving the safety and security of Canada and Canadians. Thank you. Merci. Miigwech. I welcome any questions, Mr. Chair.
Thank you, Commissioner. We'll now go to our first round of questions, beginning with Mr. Brock for 6 minutes.
Thank you, Chair, and welcome, Commissioner. It's always a pleasure to have you attend a committee. Looking forward to your evidence. I'll get right to it. Unfortunately, most recent events have been not only tragic, have been disturbing, but in my view, it has galvanized public opinion. It has galvanized police services. It has galvanized police associations, police chiefs, advocacy groups, Canadian public, that there is a serious problem with the bail system here in Canada. Would you agree with me, sir, that given your recent statements in the last few weeks, you've been extremely critical of our bail system? Do you agree, Commissioner, that our system is broken?
I definitely feel that our system is in desperate need of some very meaningful change that will ensure repeat violent offenders who have shown a propensity for using weapons against victims are held accountable and held in custody so they can't further victimize innocent community members and risk the lives of police officers. Change is needed.
And we clearly both agree that the vast majority of Canadians charged with criminal offenses, rightfully so, exercise their constitutional rights to be presumed innocent and to be released on bail. This study is not about those individuals. This study is about the individuals that you just quoted in your statistics, which I didn't do the math on a calculator, but by my count, we're talking about 80% are repeat offenders that the OPP are charging on a regular basis. And of that 80%, we have individuals who are using firearms. You agree with me, sir, that firearms, not only in Ontario, but across this country, has seen a considerable spike in terms of its usage in the commission of crime over the last several years?
Absolutely, I would agree with that statement. Day in and day out, my officers are seizing more firearms than we ever thought would be available in communities across this country. Just 3 days ago, we had an offender that had been released on bail for possession of a firearm. Within days of being released on bail, was arrested in the possession of numerous firearms yet again.
And would you agree with me that I'd say 100% or pretty close to 100% of all the criminals who freely use guns in the commission of the offense are those very same individuals who treat bail release papers as a piece of paper only with no obligation to comply?
I would agree that we see a higher rate of violation of bail conditions for those that use firearms in the commission of violent offenses.
We both agree that the senseless murder of OPP officer Priscilla did not have to happen if the system worked as planned, correct?
Correct.
There was a breakdown in terms of the decision that the justice made at the bail review stage. There was a breakdown in the level of supervision that his own mother was providing to this individual. This individual, you would agree with me, was released on the highest rung of that proverbial ladder that the Supreme Court of Canada references in ANTIC. House arrest, electronic monitoring, not possessing any weapons, not being out at all unless he is with his mother for court appearances and attendances at his lawyer's office. You couldn't get a stronger release than what the justice released that individual on. Would you agree?
I would agree.
And yet that very same individual disregarded everything that the justice had said, including not attending his very first court date.
Correct, sir.
So, with the little amount of time that I have, I'm going to ask you specifically, what reforms and what amendments would you like this committee to consider, sir?
Thank you. In expansion to my reference to Section 515, subsection 10B in my opening statement, those public safety considerations that need to be given due weight and consideration, I would like to see expansion of reverse onus provisions for firearm possession offenses as they relate to repeat violent offenders or serious prolific offenders, and a definition of a serious prolific or repeat violent offender. Codified public safety considerations before bail is granted, and greater surety accountability for those who take responsibility for those who have been released.
Thank you. Chair, I'm going to cede my last 30 seconds to my colleague. Thank you.
Thank you, Commissioner, and I believe everybody on this committee sends their condolences for the loss of your fallen officer. It's people like you and people like him and all of you who keep us safe, so thank you. Commissioner, I tabled recently Bill C-313. Have you had a chance to review that, Bill?
I have, sir, yes.
Okay. Are you able to provide any commentary on that to this committee in a few seconds, or your position on it?
It is very consistent with the same recommendations that you have heard from me thus far before this committee, and very consistent with the recommendations I'm hearing from other police leaders right across this country.
Thank you.
Thank you, Mr. Caputo. Thank you, Mr. Brock. We'll next go to Ms. Briard for 6 minutes.
Thank you, Mr. Chair. Bonjour, je vais vous parler en français.
I'll be speaking to you in French. Can you hear the interpretation? Yes? Okay. So it's my opportunity to express all my condolences on the loss of your colleague, and also thank you for protecting the people of Ontario. I was listening to your comments. You talked about significant changes, being responsible, and you replied to Mr. Brock regarding those issues. What are you proposing in terms of a change?
Thank you. The changes that I am proposing, you will find in my opening comments as they relate to codifying what needs to be given weight as public safety considerations. The expansion of reverse onus provisions as it relates to firearm-related offenses, and repeat violent or serious prolific offenders, and greater surety accountability.
Est-ce que vous croyez que c'est par manque?
Do you think that it's due to a lack of information that sometimes judges may make decisions that are, shall we say, unfortunate?
No, I don't believe it's as a result of a lack of information. I believe it is the interpretation of the legislation that is currently provided to them to work within. And I think there's an opportunity to modernize that legislation to ensure that the appropriate weight is given to not only uphold the Canadian Victim Bill of Rights, but to ensure public safety. There is definite direction that is required in legislation. The legislation is currently written is, for the most case, being appropriately interpreted, but there needs to be further direction codified.
Est-ce que vous avez confiance?
Do you have faith in the judiciary and those who make the decisions regarding bail release?
I think every case has to be weighed on its own merits, and I do believe that there is reform that can take place that will assist those that are entrusted with those very difficult decisions, that they have the appropriate legislation to assist them in making decisions that are in the best interest of public safety.
Vous savez aussi que
You also know that by default, the rule is that the accused is released and the exception is detention. Do you believe the suggested changes you put forward would in a way counter, perhaps I'm mixing two things, the presumption of innocence and this constitutional right to be released until one is tried? So there are two aspects to my question then. The presumption of innocence and the idea of being released until one's court case?
A very important question, and thank you for asking that. I do believe in the presumption of innocence under the Charter, and those being entitled to reasonable bail at the earliest opportunity and on the least onerous terms, unless justified otherwise. However, reverse onus requirements are absolutely essentially needed for repeat violent offenders who use weapons in the commission of violent offenses. In those cases, the onus clearly should be on the accused to show why they ought not to be detained and that public safety is given the appropriate consideration and weight, that we don't see more violence in our communities at the hands of these offenders.
Est-ce que vous pensez que selon
Do you think that based on the nature of an offense, some individuals should not be detained and should benefit from rehabilitation in the community or something along those lines to avoid reoffending, recidivism? Because we know that detention can actually lead to some people committing crimes once after their release.
Absolutely. I do believe in the principles of the Charter and the principles in which bail is constructed. However, we are talking about a very select number of repeat violent offenders who have a criminal history of committing violent crimes and using firearms in the commission of those offenses. My scope is very narrow, very responsible, very impactful, and extremely essential to public safety.
Merci.
Thank you. And on the issue of public safety, indeed, that's something that matters a great deal to me. What can we do to better protect victims? You're going to say, keep people in detention, but in a broader sense.
Well, I would not give a blanket answer to keep people in detention, save and accept the advice that I have already provided. So repeat violent offenders or serious prolific offenders who continue to victimize communities, who use weapons and firearms in the commission of an offense, those offenders need to be detained in custody until they have had their trial.
Parfait. Merci beaucoup.
Perfect. Thank you.
Thank you, Ms. Briard. Next, we'll go to Monsieur Fortin for 6 minutes.
Merci, Monsieur.
Thank you, Mr. Chair. Thank you, Mr. Carrick, for being here with us. First off, I, of course, want to extend my condolences for the loss of your colleague. Of course, these are events we would rather never have to experience. On the issue of bail release that we're now looking at in this committee, I'd like to hear your view on the impact of some other legislative provisions. I was discussing this with the previous panel. We passed Bill C-5 not that long ago, and it repeals mandatory minimum offenses for some penalties for some offenses, firearms offenses specifically, discharging a firearm with an intent, which I think is a relatively serious offense. And for that type of offense, C-5 provides that there is no more mandatory minimum for that kind of offense. So does that kind of decision by the legislator affect the decision made by the judge at the bail hearing? Based on your experience, is that going to be taken into consideration? The fact that the crime, the offense that the accused is charged with is perhaps less serious given the fact the legislator chose to abolish the mandatory minimum for that very crime.
Thank you for expressing your condolences and thank you for your question. I don't know that I'm qualified to speak on behalf of what a judge may take from those legislative changes, but as a police officer, I can tell you that it does send a message that those offenses are deemed less serious when minimum penalties are abolished. A minimum penalty sends a strong message that these are amongst the most serious offenses that require the most amount of consequences and justice to ensure the protection of Canadians.
Thank you. In the same vein, Mr. Carrick, some prohibitions have been repealed. For instance, So now you can have conditional sentences. I'm not sure how to say peine avec sursis in English. I'm not sure if you know what I'm talking about, where you can do this at home. So in society rather than at home. Or rather than in jail. Do you understand what I'm saying?
Sur ces peines-là,
Okay, on those offenses in the past, you couldn't impose them for some. But now, sexual offenses, for instance, that type of offense could be subject to a sentence. How can I put this? So the conditional sentence, as you say, peine avec sursis. Do you think that's one aspect that could be taken into consideration to say, I mean, for the court to say, okay, the individual is accused of sex assault. There's a hearing related. So there's a bail hearing. Could someone not say, okay, well, the sex offense is now potentially conditional sentence type of offense, and there's no need to detain that person prior to the trial. In your view, what do you think?
So if I understand the question correctly, sir, please forgive me if I'm losing pieces of it. I do believe where the sentencing restricts a judge in what they can impose on terms of sentencing, if convicted, will have an impact on decisions made related to bail and judicial interim release conditions.
Merci. Et vous êtes, bon, policier, évidemment. De votre expérience de...
Okay, you're a police officer. Could you tell us from your perspective what impact have these decisions had when it comes to the criminal world, if you will, as a police officer, based on your experience? Do you think people will tend not to take these types of offenses as seriously, perhaps engage in them more lightly than they might have in the past prior to the legislator making that shift away from mandatory minimums?
Well, I think I can rely on the statistics that are available to us, and between 2018 and the end of 2022, we saw a 72% increase on cases of serious violence involving accused persons reoffending while on release for previous serious offenses. So I think those statistics speak for themselves.
Okay. Et
you have some recommendations. Can you summarize in just a few seconds how you perceive, I mean, what should we do quickly, we as a committee, to counter this problem and find a way to make sure that dangerous offenders are not released into the community?
I think we can very quickly make the legislative amendments that are required to expand on reverse onus provisions and to codify what public safety considerations need to be weighed when considering interim release. These are very straightforward. There's a number of private member bills that have been introduced. There's recommendations from the chiefs right across the country. They are not wide spanning changes that are required. They are very responsibly focused, and I think they can be done very effectively and very immediately. And I will draw your attention to a 2008 resolution from the Canadian Association of Chiefs of Police. That's almost 15 years ago, that made these very similar basic recommendations. And if we just reflect on the amount of victimization that could have been prevented had somebody taken responsibility to make those changes 15 years ago, we could have saved a lot of victims and a lot of families a lot of heartache.
Thank you,
Merci,
Mr.
Mr. Gary.
Next to Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair, and thank you to the Commissioner for being with us today. And I want to join my colleagues in expressing my condolences to the force for a loss of a member. I know, as a former police board member municipally, that any time the members suffer serious violence or even death, it has a major impact on the force. And I wonder if you could just say a little bit about how you feel this has impacted the OPP.
Thank you, sir, for expressing your condolences, and thank you for previously serving on a police services board. It has dramatically impacted our members and Greg's family. Their lives are changed forever. We will have police officers that will never come back to work because they've been so dramatically impacted by this. We have others that will live in fear of every radio call, every traffic stop they make. We have their partners and their children living in fear every time they walk out the door to go back to work. These are not conditions that those that we rely upon for the sanctity, safety, and security of our communities should have to face. And we, as officials, I think, have the ability to make some meaningful change that will bring some peace to them, bring some resolve, and ensure that we have their best interest and their safety at mind. There's no other profession that each and every day they not only risk their personal safety, but their psychological well-being and the sanctity of their families for our safety and well-being.
Thank you for really making that clear to all of us here.
Thank you.
I want to ask you a question about the person who was accused, is charged with Constable Purcella's murder. I always make it a practice in public never to say the offender's name because some of those seek that notoriety. Do you believe the judge had full information on the previous misdeeds, I guess I'll call them, of this offender when the judge was making the bail decision?
Yes, I do.
And in that case, what you're saying to us today, and I appreciate you said you're taking a narrow scope here, would the reverse onus of the conditions of bail have led to a different outcome of that bail hearing, in your opinion?
I think they very likely could have. Not only the reverse onus conditions, but the codified public safety considerations that need to be weighed against the other very meaningful circumstances that a judge must take in or a justice must take into consideration. Codifying those public safety considerations would be very helpful, I believe, moving forward.
And so by that, do you mean having an explicit list in the criminal code of things that must be considered in terms of public safety?
Yes, sir.
And I think you also said, I'm just looking in my notes, and I'm kind of missing, I didn't keep very good notes, I have to say. A definition of a public, I think you called it prolific violent offenders, is the second thing you're calling for. So would that mean specifying number of offenses, kinds of offenses, that kind of in the criminal code?
That's exactly what that would entail, sir, yes. Specifying the types of offenses and in some cases the number of offenses that one would have previously been convicted of to be defined as a repeat violent offender or a serious prolific offender, and deciding on one of those two definitions, but what that definition would be.
I appreciate the very practical suggestions that you're making for the committees. Quite often we have lots of rhetoric and not so much on the practical end, so thank you for that. Also, again, you've said a very narrow scope, and I think it's important for us to keep in mind that there's, I don't know the exact numbers, but there's probably over somewhere between 50 and 70,000 people who achieve bail in Ontario in a given year. And so we are talking about, when you talk about 587, that's obviously too large a number. But of the bail system as a whole, it's a very small number of the cases. Would you agree with that?
It is a small number of the cases, and we know, and I know there's many former Crown attorneys around this table, or a number anyways, we know that it's a small number of offenders that commit the majority of violent offenses, and they are those prolific offenders that we are focused on.
In my own community, we have a different concern, and that's about repeat and prolific nonviolent offenders and their impact on, in particular, small business and public safety fears in downtown areas. And I think that's a different issue, but I think it's one we also have to look at in this committee. And could you give us some of your thoughts on that problem, which is a different problem, but I think a real problem that we need to tackle?
It is a different problem, but it is a real problem, and one that certainly is of great concern to us are fraud offenses that victimize seniors of life savings and those types of very dramatic financial impacts to communities and to businesses. And I think it comes down to meaningful consequences and true rehabilitation, and that's something that I would be hesitant to provide any meaningful and direct feedback on, but would welcome an opportunity to sit down as part of a larger group and have some meaningful discussion on, because I think there are some solutions that collectively we could contribute to.
And do you think that the recent, I guess I'll say, spike in random violence incidents, for instance, in the city of Toronto and on the transit system, do you think any of that could be related to the bail system? Have you seen evidence of that, or is that not the case?
I do believe it could be related to the bail system. I can't specifically relate to the violence on public transit, but the overall violence. And Chief Myron Demke of Toronto Police would tell you that he has statistics that are absolutely alarming over the number of people that are released on bail that fit the definition of a repeat violent offender, having used a firearm in the commission of an offense, and then reoffend and reoffend and reoffend up to 3 times. And 17% of Toronto Police's homicides fit into that category.
Great. Thank you very much, Mr. Chair.
Thank you, Mr. Garrison. We'll go to our next round, beginning with Mr. Van Popta for 5 minutes.
Thank you, Chair. Thank you, Commissioner, for being with us here today. And I'm going to join with all my colleagues in expressing my condolences and the condolences of people in British Columbia for the tragic death of Constable Greg Pershella. You're outraged. We're all outraged by it. And in British Columbia, it's still fresh for us that Constable Shaylin Yang of the RCMP was also murdered while in active duty. So it's very heartbreaking. So it's an important study that we're undertaking on bail reform. And you were quoted as saying, "We as chiefs of police right across the country are asking for a narrow, very narrow scope that deals with the most dangerous offenders, and that'll ensure safety." So I'm going to ask you, and it's perhaps repeating a bit what Mr. Garrison was asking about, but how do you define narrow, very narrow?
I define narrow and very narrow by being very specific in relation to the types of offenses and what would constitute a repeat violent offender. It is a distinct pattern of violent criminal behavior that have led to criminal convictions before the courts and evidence of convictions of having used weapons and or firearms in the commission of those offenses. That is how I would articulate a narrow scope that will have the greatest impact on public safety.
Good, thank you. Now you've mentioned repeat offenders, and of course this study is about bail reform, which is narrower than just the broader topic of repeat offenders. So is our study too narrow? Should we be talking about other other issues that are perhaps could be introduced to restrain or to reduce repeat offenses happening?
I don't think your study is too narrow, and my reason for that is change is needed immediately. If you stop and talk to any police officer in any community across this country, they will tell you that their top priority is to see bail reform. We owe it to each and every one of them. We owe it to victims of violent crime. We owe it to victims of intimate partner violence to make these changes now. My challenge to all of us would be to expand on that scope after those changes have been made. If you make your scope too large in this study, it will take too long to make that change, and the time for change is now.
I understand, and I do appreciate that. But your Greg Pershella was murdered by somebody who was out on bail for a firearm, for a previous firearms crime. But Constable Yang was murdered by a person who was not out on bail, but in an environment where there's a lot of repeat crime. So I appreciate what you're saying, that let's narrow the focus, let's study this, but there's more work to be done.
Absolutely, there's more work to be done. It takes a holistic approach, which requires very detailed and critical systems thinking, but we cannot let that stand in the way of progress. We can't stop with these changes, but we need to start somewhere, and I think this is a very appropriate and responsible place to start.
I'm going to ask you a question about statistics, and you shared some statistics with us. And I don't know if this is available, but I would like to know the impact that C-75 had on policing work in Ontario and across the country. So C-75 has been with us now for about 4 years. I think it was June 2019 that it received royal assent, and it amended some of our bail rules. Do we have statistics of what policing work was like before and after that date?
One of the statistics that I've already referenced that I think would be helpful context in looking at various bail reform initiatives in the province of Ontario, we identified that between 2018 and 2022, there's been a 72% increase in violent crimes committed by serious, prolific, or repeat violent offenders. And I think who were on bail, yes.
Good, thank you. Good. I don't have any more questions.
Nope. Thank you, Mr. Van Popta. We'll next go to Ms. Dillon for 5 minutes.
Thank you, Mr. Chair, and thank you, Commissioner Carrick, for being here. And from myself as well, we were very heartbroken when we saw the news about the officer being murdered in this manner. It's always tragic. It's very hurtful to see that as well, because police officers are out there protecting us, trying to keep our communities safe. And when this happens, and a young man like that, very heartbreaking. So our condolences as well. And I'd like to start with some of the testimony, your testimony, your answers. You spoke about interpretation of the legislation to have it further codified, some direction. Can you please elaborate a little bit? I know we're short on time, so everybody asks questions quickly. If you can elaborate as much as possible, please. Thank you.
Certainly, and thank you for your condolences. And if you don't mind, I will take you back to some of the recommendations that I cited in reference to Section 515, subsection 10B of the Criminal Code. We're actually identifying those things that need to be given appropriate weight as they relate to public safety before considering the release or while considering the release of an offender. And that is to prevent the commission of a serious offense, the prior commission of a serious offense while out on bail, the prior commission of an offense while using a weapon, in particular a firearm, the extent to which the number and frequency of any previous convictions of the accused for serious offenses indicate a persistent serious offending by the accused, and then very important, the nature and likelihood of any danger to the life or personal safety of any person or danger to the community that may be presented by the release of a person charged with an offense punishable by imprisonment for a term of 10 years or more. I think that type of codified instruction as to what ought to be or needs to be weighed would be extremely helpful in achieving public safety.
Thank you for that. And can you describe the responsibility of police forces during the bail hearing and their responsibility, their kind of enforcement of the conditions?
So we have an obligation to assist in the prosecution of an offender, which would include a bail hearing. So we would work with the Crown Attorney on making any met recommendations as they relate to conditions of release and or specific to secondary grounds to be considered upon release. Once an offender is released, the police have the ability to check on compliance for bail conditions, but these aren't always necessarily evident to the police. So I'm visiting Ottawa today. If I were charged, released on bail, and I go back to Toronto where I reside, Toronto police have no idea that I'm residing in their community. There is no means by which to identify me until they come into contact with me that I am an offender residing in their community. So there are initiatives on the way to ensure that that information is shared. But one thing I think is important to realize, that there is only one person responsible for abiding by conditions when on bail, and that is the offender who has entered into an undertaking with a justice. And there may be a second person, which is the surety that has taken responsibility for their adherence to those conditions, and those sureties also need to be held accountable when they do not fulfill their obligations. And it is extremely rare that any form of deposit is ever forfeited, and there are professional sureties out there that are putting up deposits with our monies without deposit for numerous offenders and not fulfilling their obligations. They are called professional sureties in the police world.
And in this vein, can I ask you about bail supervisors, please? Could you talk to us about their role?
So we will have most police services have high-risk offender units or other units of that type. We call ours a crime abatement strategy, where we do our best to identify those offenders who are out on bail that pose the highest risk to community, and we'll do proactive compliance checks to ensure that they are complying with those conditions. And when they are found not to be in compliance, the appropriate course would be to arrest them, if you can locate them. And I will highlight the case of where Constable Pershella was killed. Mr. McKenzie cut off his GPS device, and he was nowhere to be found. So where does a police officer even begin to look for somebody who does not want to be located, who has disregarded a GPS monitoring device that was part of their conditions? Extensive efforts were undertaken by 2 police services of jurisdiction, including taking out 2 warrants for the arrest of Mr. McKenzie. But prior to being able to apprehend him, despite extensive efforts, he had the opportunity to murder my officer because he was released from custody.
Thank you.
That's it?
Thank you, Ms. Dillon, yes.
Oh, okay.
Next, we'll go to Monsieur Fortin for 2.5 minutes.
Thank you, Mr. Chair. Mr. Carrick, I'll get back to the subject I was raising earlier. Would you say, I mean, in your view, is there a direct link between bail releases, the repealing of some mandatory minimums, and the option of a conditional release in the case of some sex-related crimes? Is there a link between all of these things that would complicate your job in a way and increase levels of crime?
Without having statistically looked at the other components other than bail release, I can't say conclusively, but I can tell you anecdotally, my professional opinion is yes.
Merci, Monsieur Carrick.
Thank you, Mr. Carrick. I have no further questions.
Thank you, Monsieur Fortin. We'll next go to Mr. Garrison for 2.5 minutes.
Thank you, Mr. Chair. I guess it's a difficult line of questioning to somebody who supervised an officer who died, always. But how have you found the response of people like us that you've been talking to? Do you feel like that you're being heard in your demands for change?
Absolutely, I do. And I think this is testimony to the demands for change being heard. This is the second standing committee that I have appeared before in the last 2 weeks, a provincial standing committee prior to this. To the first time in my knowledge of the history of our country, we had all premiers unite in a single piece of correspondence to our Prime Minister asking for bail reform. So I think Canadians overwhelmingly are supportive of the changes that we are asking for and overwhelmingly support our police and recognize how difficult of a job they have. And they know that they need the proper judicial infrastructure in place to maintain their safety and security.
Thank you. I'm very glad to hear that. And I think, of course, you know that all parties agreed here on the Justice Committee this was a problem we needed to deal with and to deal with quickly. So thank you for being here tonight.
Thank you for the opportunity.
Thank you, Mr. Garrison, and that concludes our round. I also want to express my condolences on your loss, and for me personally, I have a brother-in-law as a police officer, 2 best friends are police officers, and I grew up in a family with police officers all over, so you can only imagine the pressure, and so we are all here together to figure out a way to make sure that this doesn't happen ever again. So we thank you for your testimony and your very clear and concise opinion and message on this. So thank you, and that concludes the meeting. You are now adjourned.
you.